just wanted to run through the general agenda that we're going to be discussing this afternoon. The current workplace exam requirements and the MSHA program policy actually issued last summer is where we're going to start. It makes sense to kind of orient ourselves and go over what the rule currently states, and then from there we're going to go through the proposed changes. And as an operator, how will this affect you? What can you do to respond to these proposed changes down the road? And and what this means for your operation, because there are going to be some, for many of you, major changes to your work practices in responding to these proposed rules when they do go into effect. And we're going to end with the implementation and compliance of the proposed rule, kind of bridge those two topics together. And I'd like to get started now, just going through what the rule currently states. And the current rule is 56 and 57 18002, and some of these definitions and some of the aspects of the rule will not change. And I'm just going to start by discussing the competent person aspect of the current rule. As you can see in the slide, the competent person designated by the operator shall examine each working place at least once each shift for conditions which may adversely affect safety and health. The competent person aspect of the current rule will not change, and we're going to discuss that a little further down the road, but the definition of a competent person will not change. The second part of this, the current rule, is the record-keeping aspect, and the record that such examination was conducted shall be kept by the operator for a period of 1 year, and that aspect of the rule will not change as well. The conditions that may present an imminent danger, which are noted by the person conducting the examination, shall be brought to the immediate attention of the operator, and all persons will be withdrawn from the affected area. This is kind of an overlooked section of the current rule, and again, this is an aspect of the rule will not change, so that's important to note. And as I mentioned, some definitions that I'd like to discuss that are important for you to fully understand, and how they're currently stated and how they may change or may not change under the proposed rule. The definition of a competent person, it's a fairly low bar for an operator. Essentially, almost any of your hourly miners can qualify as a competent person. Competent persons can conduct a workplace examination under the current rule, and they just have to have a certain level of experience on a mine site. It is a low bar, and this is not changing. There was some discussion last summer when the program policy did come out whether MSHA may increase the requirements for a competent person. There was some discussion concerning whether they would mandate that supervisors or foremen conduct these examinations. Those aspects of this definition are not part of the proposed rule. There was some discussion about raising the qualifications, and at this point, that's not done. There were some best practice recommendations made, and MSHA is still standing by those best practice recommendations to possibly institute a supervisor or a foreman as that person to conduct the workplace examination, but it's just a best practice recommendation. It's not a requirement under the proposed rule, and it's not a requirement currently. The working place means any place in or about a mine where work is being performed. It's a pretty straightforward definition on its face. If miners will be working in an area, if any work is going to be done in a specific area during that specific shift, it has to be part of that daily workplace examination. The definition of a working place is not changing based upon the proposals on the table. MSHA did expand a little bit recently concerning some questions industry had about the definition of a working place under the proposal, and we're going to go through that in some more detail later. But the important thing to remember from this slide is that the definitions of a competent person and a working place are not changing under the proposal.
All right, everyone, good afternoon. I'd just like to take a quick moment and address or introduce myself. My name is Nick Scala. I'm the other co-chair of the MSHA practice group at Conn Maciel Carey with Justin. As you've probably garnered from looking at the materials moving forward and from the topics we've been discussing, we are attorneys that represent companies in mine safety and health litigation. And that stems from basic inspection and inspection contests through incident and fatality management, defense of agents of management in 110 applications, as well as working with you to go through proactive compliance methods and improving training and improving company policies and procedures so that we are moving forward from enforcement by the Mine Safety and Health Administration. Now, with that said, we also want to take some time and discuss not only what's on the horizon with this proposed rule and how that might change, but as Justin just went through, the existing rule. As you can tell from what Justin was saying, many aspects or all aspects of the existing rule will be included in the proposed rule. So we're looking at new additions and new modifications. And Justin mentioned that we are also looking at best practices, and maybe some of those best practices that MSHA has put forth are going to be rolled into this proposed rule and make them no longer best practices, but instead a rule, a part of the standard that is required as opposed to suggested by MSHA, and therefore is going to be enforceable. But this isn't the only thing that's happened recently with the workplace exam regulations for metal, non-metal mines. The last few years, there have been MSHA program policy letters released on the workplace exam rule, the most recent one being last year in July 2015. And what this rule really did was it kind of put into writing a bit more what MSHA is looking for in their definitions of a competent person, as well as how they're going to go and determine what is working places. Now, again, this is a policy letter, and policy letters are not binding on mine operators, but they do give a very good area or a very good idea of where MSHA is leaning in their enforcement in the gray areas. So, the bottom part of this slide is an excerpt from that program policy letter, and it's discussing, generally what they are looking for in a competent person and what the examiner who does the workplace exams each day should be able to recognize. And so they're talking about recognizing or the recognition of hazards and adverse conditions that may be in a work area. They make a best practice that it is a foreman or other supervisor to conduct those, but as Justin said, that is not a requirement. It could also be an experienced non-supervisory miner, which we see frequently around the country. But it's really looking at, someone with experience, which when we look at the definition that was up previously, is a big part of what is a competent person. It's someone who has the abilities and experience to qualify, and that's a determination made by you. We can look further at the program policy letter and, a bit more towards what has been a growing trend in MSHA regardless of the somewhat area, meaning it's not just isolated workplace exams, but this is another excerpt from the program policy that states if a trained, competent person fails to identify multiple safety hazards, or if multiple trained, competent persons fail to identify similar safety hazards, this may indicate task training as required was inadequate or did not occur. So, I'm sure all of you can give at least one story about task training in the last few years being discussed with MSHA or enforced or being instructed that your task training was inadequate. And that's a term that we see a lot and that we're going to discuss multiple times throughout the day. So what is adequacy? Well, unfortunately, it's a very subjective term that we don't really see at the same standard, whether that's from field office to field office, district to district, or especially from inspector to inspector. So what constitutes adequacy? And that's a big question on competent persons, is how adequate does the training have to be? Now, again, this is a situation where you are designating a competent person based on their experience that they have in the mining industry and their experience for the particular area which they will be inspecting. But MSHA is going to look at what they believe the thoroughness of that workplace exam is and determine whether or not they have adequate or inadequate task training on hazard recognition. Another area that MSHA provided some, I don't want to say clarification, but really kind of broadened the definition a bit, was with working places. And as we previously saw, the definition is any place that work will be conducted. And as Justin said, it's just where minors are going to be for the day. So the question begs, do you have to do workplace exams for areas where minors will not be, maybe abandoned or idled portions of your facility? In the workplace exam policy letter from last year, MSHA, as we can see in the second sentence in the italicized excerpt, said that this includes areas where work is performed on an infrequent basis, such as accessed primarily during periods of maintenance or cleanup. And it says all working places must be examined by a competent person at least once per shift. So, this is stating that we must do areas where it's going to be maintenance or cleanup, and that is pretty well understood. But, this rule also gives some teeth to MSHA going into different areas that may or may not be worked at that beginning of that shift or later in the day. And that's going to, for the proposed rule, affect when your workplace exams must be done. So, we can see that in the program policy, MSHA was really looking to kind of increase the scope of what is under the purview of competent persons requirements and also what is under the purview of a working area. Lastly, we just want to restate again things that you guys probably already know. What must be included in the current record? The current record for a workplace exam requires three things: the date of the exam, the examiner's name, and the working place examiner. And we bring this up specifically because the proposed rule is going to greatly expand what is required under that process, under the record requirements. They're going to be looking for descriptions, and we'll get into this all later. We're going to be looking for descriptions of adverse conditions, descriptions of corrective actions taken, when these occurred and by whom. So, from what we have been dealing with, really since the Mine Act came in and these regulations began being enforced, is going to increase a great deal for metal, non-metal operations. I see that we do have one question down in the chat box, and it's asking to define work. So work is going to be, and we could run through the definitions all day in the Code of Federal Regulations that MSHA works under, but work is going to be anything involved in the mining and milling process, whether extraction, processing, load out, and that includes maintenance and cleanup. So really it is a very wide stretch of what is going to be covered under mining operations and mining, what a miner is doing. So with that, I think Justin is going to take us through the proposed rule and where we're going from there.
So as Nick mentioned, let's take a look at some of the key points from the proposed rule that are going to be coming down the pike, and generally that we've discussed somewhat so far. So if made final, the rule will require workplace exams take place prior to work in any area. Now, to distinguish that from the current rule that we discussed just moments before, right now, mine operators are given a lot of discretion, not only what they have to include in the workplace exam, but as this points out, when that exam takes place. So you could conduct your workplace examination at any point through a shift currently, as long as it's completed by the end of that shift. Now, some of you may already be conducting your workplace examinations early in the shift, before shift, but you had that option to do so. If this rule passes, that will no longer be the case. Before work is performed in any area, that area must have been part of a daily workplace examination. Now, this may create some additional complications for you as an operator concerning scheduling, and we're going to discuss that in some more detail down the road, but this requirement obviously contains some wrinkles that as an operator you will have to deal with if this rule passes. So timing is an issue, and that will change. Timing of the exam, to be specific. The content of the workplace examinations themselves are going to be different under this proposal. Right now, it's a general theme concerning the current rule that the operators are given a lot of discretion concerning timing of the exam and content of the exam. It can be very limited currently. You can have a check that something needs to be corrected, and you don't really have to explain what was done to correct it, who corrected it, or provide any additional detail if you don't want to. That will not be the case going forward. MSHA wants the records expanded to include descriptions of potential hazards concerning the condition found, descriptions of the abatement or corrective action, when the hazard was abated, and by whom. So you're going to be including the names of your miners. You're going to be including what they did to correct it, and when that correction was done. Again, this will create additional complications that may have an impact with how you're enforced, and we'll discuss that in some greater detail down the road as well. But of course, the more detail that we put in here, you can imagine the more scrutiny it will be under during inspection, and we will discuss that. A third aspect of the proposal that we want to discuss is the call under the proposal for the competent person who is conducting the exam to sign and date the record before the completion of each shift. Under the current rule, the person conducting the examination is not required to sign his name and certify that he did conduct it. Putting your name to a document like this raises several liability issues. Again, we'll discuss them in greater detail, but as you can imagine, with MSHA expanding potential 110 action against not only people who we consider agents of the company, but possibly even hourly miners who are conducting these workplace examinations, signing this document may have a direct impact for whether that person is held liable if an inspector thinks that something was done improperly concerning that workplace examination. And we also want to discuss, the process by which this rule was proposed and when industry had an opportunity to comment on it. And MSHA actually did respond to those comments, and we'll discuss those as well. The comment period is still open. It ends on September 30th, 2016. That was extended because industry did have such a response to this proposal. And the comments made during the open hearings in Salt Lake City, Pittsburgh, Arlington, and Birmingham, really caused them to, take a moment of pause and understand that they needed more feedback and they needed to clarify certain aspects of this rule, and that's why, this proposal rather, and that's why the comment period was extended. I myself personally attended a couple of these hearings, and they were impassioned to say the least. The industry has a lot to say about this proposal. There are a lot of concerns. A running theme that I observed during these open hearings is clarification. At the outset, MSHA may have felt that they said all that needed to be said on it. Industry felt otherwise. And industry wanted clarification on the level of detail. We're going to discuss in a few slides the notification of any hazards found. Industry wanted more feedback and clarification concerning that aspect of the proposal. And the timing of the exam was a concern at all of these open hearings as well. And it's good to know that MSHA at least took our feedback seriously and allowed for additional comments. And but it is important for you to know that even following this presentation, if you do decide you want to comment, you still have time to do so. However, do expect MSHA to make every effort to finalize this rule before 2016. There's a reason why MSHA is so behind the proposal. They do feel that it is a direct link to the trend over the past few years in a rising level of fatalities at metal, non-metal mines. So it is a top priority for them, and we expect them to push it through in one form or another. It remains to be seen whether some of the modifications will be amended in some way, but MSHA is very much behind this rule, so it would be surprising to everyone to see this rule not pass in some form. Wanted to go into some more detail about the proposed modifications themselves. Read Section A here under the proposal. A competent person designated by the operator shall examine each working place at least once each shift before miners begin work in the area for conditions that may adversely affect safety or health. This again goes directly to the timing proposal of this proposed rule. Before work is performed in this area for many mines does mean that before shift starts, the workplace exam must be performed. And again, this does create some complications for you. One of the points brought up during both of the open hearings I attended was timing of the exam. Whether if it's done before shift, will it be too dark to do a thorough examination? The timing of the exam is a concern. We're going to go into more detail about that, but that's one of the major proposals that MSHA feels would have a direct impact towards decreasing this trend of a rising level of fatalities. Anything found, MSHA feels if it's done before shift and corrected before shift, before work is done, then it'll have a direct impact. Continuing on in this slide, the operator shall promptly notify miners in any affected areas of any adverse conditions found that may adversely affect safety or health. This is the notification issue that I discussed before, that I mentioned before rather. Any potential hazardous conditions found must be notified to every miner working in that area before work starts. There's some issues with the notification, how it's done. We'll discuss that in some more detail in a few slides later on in the presentation. And what I mentioned earlier in the presentation, one of the more overlooked aspects of the current rule that is not changing is the imminent danger requirement. Any imminent dangers found shall be brought to the immediate attention of the operator and then all persons withdrawn. Fairly common sense there. It's not changing. MSHA feels it's pretty clear in the current rule. It will be brought in its current form under the proposed rule if it does pass. And lastly, for this set of slides, we want to discuss the record aspect, the record-keeping aspect. A record of each examination shall be made, and the person conducting the examination shall sign and date the record before the end of shift for which the examination was made. We discussed the signing issue. That is a new proposal made under this potential new rule. Currently, you don't have to sign under the proposed rule. You will. The detail of the examination record itself, as we discussed, will change. MSHA wants more detail, specifically a description of the corrective action taken, the date that the corrective action was taken, and the name of the person who made the record of the corrective action, and the date of the record of the corrective action was made. All of this is new content, and it still remains to be seen exactly what level of detail they want for each of these aspects. For example, the corrective action taken, how much detail do you need to go into? Do you need to name every miner who did it? Do you need to mention the equipment that was used? Industry's requesting feedback. At this point, MSHA has not clarified that aspect of it. They want more detail. This is what they want. Like most things on inspection, it may come down to the discretion of each one of your individual inspectors. We'll still have to see. And the operator shall maintain the examination records for at least 1 year and shall make those records available for inspection by the AR, authorized representative. That has not changed, and that will go in its current form into the new proposed rule.
We're going to take some time now to discuss the individual changes that were just highlighted in the last few slides that Justin went through. And we're going to look at them in a bit more detail, comparing what was proposed and what's currently the regulation, and then what some issues that we anticipate if this rule is finalized in its current form. So first we'll look at the requirement or the proposed requirement that MSHA wants to impart, that workplace exams must be completed before miners begin work in any area. Currently, we know that the rule just states a workplace exam must be done once per shift. There are no requirements as to when that must happen. Here, where MSHA wants to say, before you work in an area, it must go through a workplace exam to see if there's adverse conditions or potential hazards for safety and health. You know, this was and has been for quite some time one of MSHA's best practices. and is, more akin to what we see in the coal industry and the standards that regulate that for MSHA. But for metal non-metal, this has not been a requirement previously. So what are some potential challenges that, could face mine operators who must perform these workplace exams before starting work or before miners enter an area? Well, as Justin said, there's logistical problems. When are the exams going to have to be completed if they are currently completed during the course of the workday? We're going to have to possibly look at requiring early starts for our workplace examiners, giving them time to complete a thorough examination prior to other miners entering the area, and also accommodating for the requirements that we notify miners, and we'll discuss that, I believe, in the next two slides. We're also going to be looking at, what areas are we working with and how many people are covering all those areas. We possibly could have had one or maybe two people doing the workplace exams for the entire mine previously because they could do it throughout the course of the day. Now, if we want to start on time or start at a specific time, we might have to do more training to determine that we have more competent persons and do a shotgun start, so to speak, in order to get our workplace exams done in a timely manner. So these are concerns that we're going to be hearing or be faced if the proposed rule moves forward in its current place. So there's also concerns that once if the miners are going in to the area and considering it clean or it's safe because the workplace exam was done, will they not be as attentive to any potential health and safety defects that might be there at that time? We know that the mining industry is a dynamic environment. Conditions are always changing, and we want our miners to be vigilant in watching out for changes in safety and health. And will this rule, essentially giving them a stamp of approval that you're walking into a clean working area, which is what MSHA wants this to be, is it going to make them drop their guard, so to speak, for changes in the mine area throughout the day? Another area of change is how are we going to handle that workplace exams now must include description of any potential or any adverse conditions discovered during that exam. Currently, there's no requirement to list the hazards or the adverse conditions, and there's no requirement to describe them. And this is a situation where we're unfortunately going to be dealing with a lot of adequacy concerns and a lot of subjective opinions by inspectors. Was your description good enough of an adverse condition? If you had a buildup of material that created a housekeeping issue, did you adequately describe that on your workplace exam? This is unfortunately another area where MSHA could be getting the upper hand in terms of enforcement simply by the word adequacy or inadequacy, which we've talked about with task training and training of many kinds. We've also seen it in terms of workplace exams where you are getting citations for a specific area and then they say, here's a citation for failing to provide an adequate workplace exam. And there is actually a case right now regarding that same question, whether or not just completing a workplace exam is sufficient. And we're following that litigation to see how it comes out. It's in, but that's an interesting dynamic. It went up to the commission, the Federal Mine Safety and Health Review Commission, and they remanded it to the judge to further address the adequacy issues of performing workplace exams. But in terms of this requirement, this new requirement, that we're looking at record keeping and how much of a description we have to include. As in any situation where we're wrestling with how much description to use in a record that is eventually produced to the government for enforcement purposes, we have to, weigh the aspects of, do we write very detailed notes that may, help us in the moment, but also come back to bite us in the end, or do we create a situation where we make a note to the effect that there is a housekeeping problem in this location, and the housekeeping problem was thereafter cleaned. Do we just keep it so vague, and will that satisfy MSHA? You know, one of the major aspects of this rule that has been frustrating for industry as a whole is the vagueness or the ambiguity in what MSHA wrote. Descriptions, prompt. I mean, these are all rules that there is a lot of leeway, or words that offer MSHA a lot of leeway in enforcement, which is obviously what they want. So, you know, consistency issues are going to be a problem here. Does one inspector think you're writing enough and the other does not?
So to go into a couple of the proposed modifications in some more specifics, we're going to start with the documenting of the corrective action. As you can see, under the current rule, there is no requirement to document corrective action taken by mine personnel. That is changing under the proposed rule. The date, time, and correcting miner must be recorded for any hazard discovered during the workplace exam. Now, this is an area, again, where industry wants more clarification concerning what level of detail concerning the corrective action should you put down. For example, let's say we have a guarding issue, maybe a guard has a hole in it. Do you want to state the equipment used? Miner X took expanded metal, corrected the guarding issue here, did it on this day at this time. Is that sufficient? 2 lines. And, it remains to be seen. Industry is providing feedback about that, and we'll see what MSHA comes back with. But what we do know is that the corrective action must be at least addressed under the proposal. And some challenges with these proposals that Nick generally mentioned before. The requirement will provide these new requirements will provide MSHA with an ample opportunity to issue citations. And I know as operators, you've all been in situations where you think that what you've done, let's take the workplace exam, was completely adequate. Referring again to that adequacy term, and one inspector may completely agree with you, and another one may not. What we do know is that the enhancing of these requirements and this level of detail concerning the corrective action and the conditions found will expose mines to that potential, to the potential for more enforcement. To piggyback onto that, currently MSHA has no statute of limitations, so failure to address any hazard recorded could result in a citation. An inspector can go back into your past year log of workplace examinations, and anything that he finds inadequate about those exams, through the review of those exams and potentially through discussion with your employees, can absolutely lead to a citation. I've seen it under the current rule, and under the proposed rule, you could only imagine that it may get, even more common for that to happen. Another proposal that we want to discuss in some more detail is the notification issue. Mine operators must promptly notify miners of hazards discovered during workplace exams prior to entering that working area. This is a new requirement in every way, shape, or form. Essentially, anything found that's potentially hazardous on the workplace examination must obviously not only be recorded on that exam, but every miner who's going to be working in that area must be notified of those conditions. Now, we'll discuss this in a few slides down the road, but questions remain concerning how you're to notify these miners, in what form, and how this may come back to impact you down the road. You may want some certification that your miners actually did receive that notification to be able to show to an inspector. That may put you in a better position. But again, it remains to be seen how MSHA will actually enforce this aspect. They did expand upon it in a comment period, and when they did expand the comment period, and we'll discuss that down the road as well. And concerns again arise, as we discussed, with the adequacy of notification. There were some industry representatives at the open hearings that discussed exactly, what their questions were concerning notification. We do know at this point that verbal notification will be sufficient. as far as the rule goes, but will it be sufficient to protect you against some inconsistent enforcement? We'll have to see. Documentation of minor notification is most likely an advisable step because of that fact alone. You want to be able to provide your inspectors with some proof this was done. All of these aspects of the proposed rule will open you up to citations under this standard. We do know that. We expect MSHA to, at the very least, take these out for a test drive. The best way to protect yourself is to document as much as you can that you have adhered to the new proposals, and documenting the notification to minors is one way to do that.
And then, we've talked about this requirement, and we're going to talk about it again because MSHA's, started to maybe soften their stance on it. But under the proposed rule, MSHA wants the competent person who performed the exam to sign and date it prior to the end of each shift. Currently, you just need to put the name of the individual. So why is it a concern to go from the name of the individual to a signature? Well, as we stated earlier, there's both potential liability with MSHA and outside MSHA with, signing the document and stating the document that before work was completed on this, or commenced on this day, I inspected the area and found it to be free of hazards or free of adverse conditions that may be a hazard to safety and health. And when we have seen that MSHA already is really flexing their muscle in terms of agent investigations, particularly when they're involved in an injury, this is an area of concern because the workplace exam is going to have the signature of the individual. Also, there's concerns that it has to be done prior to the end of each shift. What happens if you sign and date that the next morning because you forgot to that evening? That could be an instance where, again, depending on the severity of the reason MSHA is inspecting the forms, if they're related to perhaps a fatality or a serious injury, that could be construed in rare circumstances as falsification of a document. We've seen similar reactions, when we have records possibly for testing of continuity and resistance, where the date may be off, and that has been construed as falsification. So that is a concern that, again, it comes down to interpretation and how that is going to be enforced. But the signature and the signing and dating has received a significant amount of pushback from the metal non-metal industry. And that is due to how we have seen MSHA interacting or how we've seen them pursuing agent liability. And again, that doesn't just come down to individuals that we may consider agents of management or foremen, superintendents, and so forth. But each individual can be considered based on the scope of their work, and this is determined through MSHA's investigation, even if they may not be an agent of management for the purposes of their employment. MSHA can determine that they are liable under those circumstances if they are found that they direct the workplace more than other minors on site, even if they are not given a specific title. And that's just one of several elements that they consider. As we mentioned earlier, MSHA did extend the comment period. I also see on a side note that we have a few questions pending in the chat, and we are going to address those. We're probably at this point just going to push them off towards the end of the conference a bit longer. But right now we have the comment period, and on August 25th, 2016, not 2015, MSHA published an extension. And they extended that comment period from September 6th last week until the 30th. So as we said, there's still time to submit comments if you so desire. In this extension, though, MSHA took some time and responded to some of the questions or some of the industry comments and pushback they've received thus far. And in doing so, we have a bit more clarity or a bit more direction on how they could change the rule if it becomes finalized, or if and when it does. But with that being said, they have not changed the proposal. They are providing some clarity in this document and looking at changes that could be made. They do not have to change it. In responding to comments, they can just say that based on their evaluation and their research, they don't find it necessary to change. With that, MSHA looked at what it means to promptly notify minors. Specifically, they break down the definitions, or what they see as future definitions of notification, what satisfies that, and promptness. In terms of notification, it would be, the requirement is that operators alert minors to adverse conditions in their working place before they get to that working place. MSHA said that this can be verbal, completed by prominent warning signage, or other forms being written. They note that in most cases, MSHA states verbal notification or descriptive signage would be needed to ensure all affected minors received actual notification of the specific condition. So again, this puts us at a crossroads of what MSHA is saying, is our minimum requirement, which would be verbal notification and or signage, and possibly what's in the best interest of our companies. And, from the legal perspective, we can tell you that having documentation that you had notified your minors of a potential hazard or an adverse condition in a specific area 2 months ago when the record was created is much better than relying on the recollection of individuals. And that's going to be something that each mine or each company needs to look at themselves, whether or not they want that to simply be on each workplace exam a check mark or a signature next to an employee's name stating that they were notified, or if they actually want them to write out, or it's a separate form. Those are going to be some of the issues that we need to look at, but as we said earlier, in our opinion, having some sort of record that employees were notified is going to be an important aspect of this, because MSHA can infer that they were not if it is not recorded. As we've found out far too many times with MSHA, if there's not a record of it, they don't believe it occurred. And so that is one potential clarification that they gave, but I think that operators would be best suited to push further if this rule becomes final.
And another aspect of the notification proposal that MSHA did clarify was an attempt to expand on what prompt may mean. And, the phrase prompt under the proposal, I don't have to tell you, will lead to some heated discussion, I'm sure, between operators and the inspectors concerning what they did to make this specific notification. According to MSHA, according to their clarification on the prompt notification, they're looking for this notification before minors begin work in an affected area, or as soon as possible after work begins if the condition is discovered while they are working in an area. So before work begins, that notification I think is fairly straightforward. If a condition is found after work started, which does happen, it's not uncommon. I believe there could be some discussion concerning, well, we did make that notification as soon as possible. One out of maybe every 5 or 6 inspectors may have a different opinion that what you did to make that notification was not done as soon as possible. MSHA did make an attempt to clarify. It remains to be seen if they'll try and clarify any further. But this is an area where enforcement may result based upon, how fast or how quickly that notification was made, or how fast it was attempted to be made. During shift assignments, MSHA feels that's a good time to make that notification. But again, there is still a gray area concerning how quickly this notification is made that may lead to future enforcement. As we mentioned several times earlier in this presentation, the definition of a working place will remain unchanged. MSHA did expand upon, what they consider a working area based upon feedback that they received during the comment period so far. Working area includes roads traveled to and from a work area. Does not include roads not directly involved in the mining process, administrative office buildings, parking lots, lunchrooms, toilet facilities, and inactive storage areas. And mine operators would only be required to examine isolated, abandoned, or idle areas of a mine or mill when miners have to perform work in these areas during shift. Now, although MSHA did make an attempt to clarify, again, like most aspects of these proposals, there still does remain some ambiguity. Let's take the roads not directly involved in mining. As an example, there may be cases where a road that you consider is not directly involved in mining, an inspector may feel differently based upon where customer trucks travel, where contractor trucks travel, where they fuel up, where they check in. What you think you're doing may, as far as you're concerned, be, may adhere completely to these new proposals, but again, it will still depend upon the individual discretion of your inspectors. It's good that they've tried to clarify a working area, and they reiterated that the definition will remain unchanged, but don't be surprised to still have some potential enforcement action for areas that you consider exempt that they do not. To expand a bit on the working area issue, working places are not the entirety of a mine unless miners will be working in all areas of a mine. Essentially, you know where your miners are going to be working during that shift for the most part. If something changes that will alter that, you'll have to respond, and that area will have to be examined. But for the most part, if your miners will be in an area performing work, it has to be part of a daily workplace examination. And this can be dependent when shifts begin, if phase start times, or if an area will not be worked in until later in the shift. As Nick and I both mentioned so far, there was a lot of pushback, and there has been a lot of pushback from industry and requests for clarification concerning the signing and dating of the record. Over the past few years, independent of the workplace exam rule in its current state or the proposal, Section 110C actions, which is, MSHA's, the section of the Act where MSHA can go after agents of the company for personal civil penalties or even potential criminal prosecution, that net has expanded. There are criteria that MSHA looks at to determine who is subject to a Section 110 Act concerning, or Section 110 action concerning, if this person has direct oversight over other miners, can they unilaterally shut off a portion of the mine? Are they hourly? Are they salaried? The performance of a workplace examination has been part of that criteria, and that will remain unchanged. Whoever you have conducting a workplace examination, it's probably a safe bet to say that they will at the very least be looked at for a Section 110 action if an elevated action is issued under the workplace examination standard, under its current rule or under the proposal. Signing that record only gives MSHA more power and more cause to go after that competent person performing the exam. And this was voiced during the comment period in multiple forms. So this is a major concern for operators, and their decision concerning who to assign this duty to will be directly impacted by these proposals. So putting your name to this record, signing and certifying that the area that you inspected is free of hazards may lead to a Section 110C action, and so far those liability issues still remain. And MSHA requested comments on the alternative of requiring only the name of the examiner and not the signature. So as you can see, based upon the comments made during the comment period so far, MSHA has walked back a bit on this requirement. They haven't changed it yet. The fact that they're requesting alternatives is a good sign that they're taking these concerns seriously. However, from where we stand today, if the rule were to pass in its proposed form, the requirement to sign the record would still pass.
All right, and then when we're looking at, creation of the records, this is also another area that has really kind of given industry some headaches because there are a lot of questions regarding when the record must be completed. Is it a, shall we say, living document that we continue to update throughout the day, or is it a document that we complete prior to shift and then move on? What MSHA clarified is that the record can be created at any time before the end of shift, meaning before the end of shift each day, we need to sit there and write down that the workplace exam was corrected in this area, or completed in this area, that there was no defects or adverse conditions found, that there were, and here's our description of it. If at that point in time we have taken corrective action, what was the corrective action taken and by whom, and at what time. So we're looking at sort of those requirements. So we don't need to wait until the end of the day to do it. We can do it at any time, according to what MSHA said in their comments and clarification. However, that does bring us back to, is this an open document? Are we doing a workplace exam and just leaving it open all day? So that if a condition does develop, we're putting it on that workplace exam. We're going to have to see how that plays out, but I think Justin and I can both agree that our initial reaction to this would be that it's better to complete the exam, complete the record, and then perhaps have a secondary sheet that we can maintain in an area noting if anything develops throughout the day. Something that is not our per se or our workplace exam officially that has to be produced. So we keep our record that was done prior to the workday, documenting who was notified, documenting what was there, what wasn't there, and then we, for existing or developing issues throughout the day, I think it'd be a wise decision to complete another or have another form of internal documentation, not considered your workplace exam. Initially, MSHA was really looking for some feedback in the realm of whether there should be a specified time before when the exam must be completed before minors enter an area. That's an incredibly difficult element to enforce, and to really put all mine operators on a rigid schedule like that. MSHA, we haven't heard a lot about this from them since the proposed rule came out in June. They did not address it in their comment period. I think that's just, at this time it is possibly a bit too rigid for them to get into, but they could always try. Also, there was questions of whether or not there should be a required minimum amount of experience or knowledge or training to be determined competent. Right now, that is the determined and the sole determination of you, the mine operator. And MSHA was, again, they're looking to refine that definition, but they know that refining or increasing the requirements under the definition of competent person or working place, any definition change is going to be a much harder fight to get through than, trying to push this rule forward with the current definitions. So they're looking for industry feedback on how they would like to see it. Right now, as in someone in the industry, I would expect I would want the definition to remain the same. I wouldn't want to put a certain amount of experience on it. You can determine if your personnel are experienced and qualified to perform that task, and it might not be as easy as just saying, oh, they have 5 years of experience, or they have 10 years. Maybe someone who has less time than that is more diligent and better suited to perform these exams. So that is another area that MSHA initially requested some guidance. So how are we going to implement this if it becomes finalized? And what are some of our suggestions for implementation if this rule becomes final or when it does? And how would we, think that a better way for you guys to go forward, or some tips to avoid enforcement on it? First, I think one of the most important aspects is we need to establish clear company policies on examination, notification, and corrective action. So Obviously we know that we're going to have to do these beforehand and begin corrective action immediately. But what are our policies? Do we have it laid out? Who's the maintenance crews, if we have that delineation, or who is going to be reporting to what area? And are we streamlining the process of correcting these actions? Because obviously, by MSHA at this point, putting in the proposed rule that they want the time the corrective action was taken, they're going to be scrutinizing how long you took to correct a certain issue or a hazardous condition that you listed on the workplace exam. So we want to try and streamline those options. Additionally, we want to still encourage all of our miners, regardless of their completing the exam or not, to report adverse conditions to management and take action to prevent exposure. Even if it occurs during the shift and we are still working out how we're going to maintain that document, if we're going to keep the workplace exam open all day or start a new document, it still needs to be reported. It needs to be reported promptly. And we need to take some action to protect miners from it. Now, whether it's a spill of material and that just simply is cleaning it up, or if a guard broke in a certain area and we need to install or create some kind of physical barrier until we can replace it or repair it. We also want to look at implementing workplace exam record templates that allow for our documentation of adverse conditions and corrective actions. And also we would, recommend some sort of section at the bottom for acknowledgement by the miners going to that area of notification. Right now, we have no set format for our exams. It can be, I've seen calendars used where it's just marked in the calendar that it was done on that day. We've seen very straightforward or very laid out forms for all aspects of it. For some operators, this new changes or these proposed modifications aren't even going to be that big of a shock. But for others, they will be. So we're going to want to start looking at how are we going to lay out these forms and what are we going to want included on those forms. And at a minimum, that's going to be areas for descriptions, area for corrective action, and we would recommend some area for notification. One area that I think is going to be questioned is when were corrections made and when was the exam made. We know that the exam has to be done before work is completed in an area or began in an area. But do we have phased start times? Are we not working in that area in the morning, but we may be in the afternoon? And we just have written that corrective action was taken at 4:30 p.m. and MSHA assumes that means we let the adverse condition lie all day. So, again, you could play devil's advocate, but at this time, I think in its current condition, we're going to want to be making some note, whether on the actual exam itself or in a supplemental notebook that is not our official exam record, that when we completed the exams in each area, so that we have that for our own information and our own defense. Again, that goes to the next suggestion is maintaining some kind of separate documentation for hazards during the day or for specific details regarding, maybe if you want to keep the actual workplace exam descriptions to a lesser extent to have more detail for your own records. Again, the notification, we want to make sure we have that on record. And then also record inactive areas. We saw in the clarification that MSHA said this does not apply to inactive or idle areas or in storage areas. They gave several lists. So if we have a section of the pit or a section of the plant that is not operating that day, we want to make record of it so that we don't have a situation where MSHA says, oh, well, you ran this pit or this plant for the preceding 7 days, and then you didn't do workplace exams for 3 days, and then you started up again. Well, it can easily be explained if on the missing 3 days our other workplace exam says this area was inactive or this area was not in operation. So that is one area that I think we could have. with that, we, would welcome all of you to check out the MSHA blog. We post on there regularly, and we do developments, and we'll keep you updated on what's going on with the workplace exams and the proposed rule. Additionally, we have a few more webinars this year, and we'll be developing a curriculum or a topic series for all of 2017, and we encourage you all to join in on those as well. With that, we're happy to answer any questions via the chat function online. We'll get to the two we have in there in a moment. And then we, obviously, if you don't have access to that or are interested, you can reach Justin and I by phone or by email. We're always happy to be a resource and talk to you guys about any questions you may have, or be a resource in that respect. So with that, we have two questions, and I'll read off the first one, and we can let Justin tackle that. But is a pickup truck or other self-propelled mobile equipment considered a working place?
Well, the mobile equipment such as that would be covered under pre-shift inspection, which, like the proposal, has to be done before that vehicle is put into operation. So it's not technically under the heading of this proposal. Essentially, the requirements are pretty similar. You have to inspect that vehicle for any potential hazards or defects before it's put into operation. Different standard, same basic requirements.
And that requirement for the workplace exams, again, that's if you're not running it for the day, you do not have to perform it for that piece of equipment. But if it does be put into operation later in the day or later in the shift, you will still have to record that. And a difference being, though, in the workplace exam versus the pre-shift inspections is there is no requirement to maintain by MSHA the pre-shift inspections if no defects are found. And if a defect is found on the equipment, you only need to maintain the record until that defect is repaired, and then you can get rid of it. Obviously that's subject to your own company policies, but that's what MSHA looks at in a record retention policy. Another question was, what about the use of electronic signatures on these workplace exams? And this is something that has come up a fair amount. We've talked to quite a few individuals who are looking at doing workplace exams as an electronic record on an iPad or a phone or anything of that nature, or even coming back and typing it in a computer. And what does an electronic signature do? MSHA has been silent on that. And, I'm not sure how they would handle it. I think it depends if your electronic signature is just the //S/ writing the name, or is it a actual signature image that you can imprint on each one. The purpose of it is to say that here's the signature of this individual, at least in his current state, and that proves that they did it. So I think that would be a question that MSHA is just going to have to flesh out. But again, we are hoping that, given their comments in the extension, they are going to withdraw that requirement and simply leave it at the name of the individual, which we have now, which then on an electronic record you could just type in the name of the individual. All right, so I think that is all the questions we have at that time. Again, please feel free to reach out to either one of us at any time. All of our contact information is up on the page, and we will be sending out the slides and a copy or a recording of the webinar within the next few days. That will be available for your review or your use, however you see fit. So thank you very much for attending our first webinar, and we look forward to working with all of you in the future. Thank you.